is in session.
Thank you. Please be seated. We've scheduled oral argument this afternoon for 40 minutes in the case of Garner versus the people. I was explaining to people this morning, and maybe I'll just remind y'all once, we record these things, so if you could announce yourself and say who you're representing, and then try to speak somewhere close to the microphone while you're doing your argument, that'd be helpful. But otherwise, if both counsel are ready, Ms. Nelson, you want to begin?
May it please the court, Mr. Chief Justice. My name is Inga Nelson, registration number 47620, and I appear today on behalf of Mr. Garner. For the past 50 years, courts have recognized that eyewitness identification evidence can present a unique danger of misidentification resulting in wrongful convictions. Knowledge of this danger has expanded exponentially over the past half-century because of extensive peer-reviewed research that identifies and explains why relying on eyewitness identification results in wrongful convictions. Indeed, out of the 350 DNA exoneration cases in the U.S., over 70% of those involved some eyewitness identification evidence. Driven by this evidence and recognizing that Colorado needed to improve the accuracy of eyewitness identification evidence, the Colorado General Assembly enacted CRS Section 16.1.109, directing law enforcement agencies to improve identification procedures by incorporating peer-reviewed research on memory and eyewitness identification into new protocols. Here, in this case, 3 brothers gave initial descriptions of a shooter that did not match Mr. Garner. They were shown Mr. Garner's photo in a lineup, and all failed to identify him as the shooter. And then, 3 years after the shooting, they were allowed to identify Mr. Garner for the first time in court, a highly suggestive setting. This case presents this court with the opportunity to modernize the procedures for first-time in-court identifications and reduce the danger of irreparable misidentification.
May I just interrupt you there, just to flesh out and make sure that we're all on the same page to start with. So you're asking us to create a new rule with regard to in-court identifications that would exclude them for being too suggestive. And that under the state constitution?
Let me clarify a little bit.
Okay.
Because first-time in-court identifications are inherently unnecessarily suggestive, they should trigger the application of the 2-step totality of the circumstances test that was articulated in Biggers. So it is simply, the first step is asking that this court recognize that that admissibility test should be applied to first-time in-court identifications. Second, this court should include additional factors that reflect peer-reviewed research on eyewitness identification and memory to consider whether they're reliable.
And I guess what I was trying to flesh out was kind of a matter of form.
Sure.
So were you asking us to construe the United States Constitution in this expanded way? You weren't suggesting, I mean, I take it by your language and in the brief, you weren't suggesting Neal v. Biggers does that or Manson versus Brathwaite, I take it. But what would be the basis of our extension in this way?
Sure. The U.S. Supreme Court has not yet ruled on the question of whether or not due process protections, so just that 2-step test, whether that is triggered by a first-time in-court identification. They have not yet addressed that. I think that this court can find that under the federal and or state due process clause, but under the federal clause, that first-time in court identifications are the type of unnecessarily suggestive identification procedure that triggers that test under due process. And then as for applying additional factors in assessing the totality of the circumstances, I would say that Biggers and Manson discuss the test very clearly as a totality of the circumstances test, directing courts to determine whether, under all of the circumstances, the reliability of an identification is outweighed by the unnecessary suggestiveness of the procedure. And because it is a totality of the circumstances test, I think this court can identify additional circumstances that courts in Colorado should consider.
Perhaps one quick follow-up. And so when they talk about suppressing or excluding the in-court identification as being tainted by an impermissibly suggestive out-of-court, you take that as them not meaning that's the basis and the only basis for excluding an in-court, but rather they left open the question, is the way you're reading it.
Correct, yes.
Okay. Thank you.
I think the Connecticut case, Dixon, they found in a very similar case that first-time in-court identifications did trigger that test. The state filed a petition for writ of certiorari with the U.S. Supreme Court, which they did not accept. So,
how does Perry v. New Hampshire affect our decision?
Sure. I think Perry was addressing, in part, this question of what types of cases fall into the scope of the due process protections. And in that case, they held that suggestive circumstances created by a private party are not the type that trigger a due process analysis, because one of the considerations behind the exclusionary rule and simply the due process test was to deter state actors. And there, because the state actors did not arrange or were not responsible for the identification or the suggestiveness of the identification, that type of identification just falls outside of the protections of due process. So the Perry court did not address the issue that's before the court here.
But some courts have extended it to in-court identifications, right?
Have extended Perry?
Yes.
Mm-hmm. Yes. Yes. And I think, I believe it's the Innocence Project amicus brief that touches on that a little bit. There's a 10th Circuit case, Thomas, which basically said it's a little unclear to me the basis that they found in Thomas for finding that Perry did not allow for the application of the test. It's unclear whether they're saying we don't apply the test at all to these first-time in-court identifications, or this wasn't a state actor because Perry only applied to police. So it's a little unclear to me exactly what the basis for that 10th Circuit decision is. The Attorney General was arguing that if it is not a police-arranged identification procedure, then that does not trigger due process, which I think is how some of those cases have been interpreted.
What was it?
Well, go ahead.
Sorry.
No, please.
What was it about this trial setting that made it unusually suggestive?
Sure. I think there's two pieces to it. First, any first-time in-court identification is inherently suggestive because it is basically a one-on-one show-up confrontation. And in addition to all of the inherent suggestiveness that goes with a show-up identification procedure, you have a defendant seated at a defense table. It is clear that the law enforcement and the prosecution has identified this as the person that they think has committed the crime. And so it provides even more suggestiveness and pressure on the witness. To add to that, we have in this case the type of suggestive circumstances that were also present in Walker, in which there was a failed pretrial identification and then a first-time in-court identification. And so what we know about memory is that there are many different ways that we might encode or recall a picture of someone. And if you see that along the stage as of storage or memory encoding of a photo, that might color your perception, your memory, your honest memory of who you saw. And so here, all of the witnesses were exposed to a photo of Mr. Garner as a suspect in this case. And then later were asked to retrieve the memory of the shooter. And so that pretrial identification that exposed them to the photo of him taints their ability to accurately recall the actual face of the shooter. And in this case, because the suggestiveness, again, was very strong just with the in-court proceeding on its own.
So sorry, go ahead. Go ahead.
Is it the having been exposed to the photos, or is it more about having been exposed to the photo and not having identified the individual at that juncture that ends up making the in-court identification yet more suggestive? I wasn't sure which of the two you're...
I think it's both.
Okay.
I think the fact that someone is exposed to a picture of someone as a suspect, and that is through the process of attempting to remember and recall faces, that is going to taint their memory, is what we know, or it has the danger of tainting their memory. So that exposure. But then the fact that they could not identify Mr. Garner as the shooter, and two of them did not even identify him as being present at the bar from the photo.
Ms. Nelson, I'm trying just to remember the facts, forgive me. Does Mr. Garner have facial hair, or did he at the time?
Yes,
All right. And am I remembering correctly, in the initial identifications, none of the three brothers mentioned facial hair?
correct.
And am I also remembering correctly that in the photos, all 6 of the people had facial hair?
Correct,
And then after the fact, they said there was facial hair?
correct. At least one of the brothers had also spoken to the fourth witness, the only non-brother witness who had been present and identified, other than the bar staff who didn't really see what happened. And I believe he mentioned facial hair as well, but they had discussed that identification.
May I take you back to Justice Samora's question if you're finished with that, Justice Gabriel?
Yes, thank you.
So back to Perry and this notion of whether it should be construed to address just police action or state action more broadly. I think you can read that case either way. I was wondering if you could elaborate on what you shared with us before and maybe help us understand why you think it would be more appropriate for us to understand it to encompass state action generally, including action by a judge, based on other cases. Because I don't know that Perry really answers it. And as Justice Moore said, you have cases going in both directions post-Perry.
Correct. Yes. I don't think Perry does address it, and I think that's because the context in which this issue arose was specifically asking whether this was sufficiently police-created conduct. And so I think a lot of the language is just necessarily focused on that because that was what was in front of the court. At one point, the court does mention state action specifically, but I think the idea that prosecutors are not law enforcement and their actions are not enough to trigger due process protections under the same grounds because they're a private party, that rationale just doesn't make sense under Perry or in reality because law enforcement includes prosecutors. Additionally, the reason that they touch on for the purpose of the distinction between state actors or police and private parties is the role of deterrence. And so the idea is that by applying the exclusionary rule in this context to impermissibly suggestive procedures when police or state actors have an opportunity or an option for using some other type of non-suggestive and more reliable procedure, that can deter that action, and that down the road, the police will not engage in those types of practices. That deterrence rationale applies here as well to prosecutors, to encourage them to not utilize a more highly suggestive procedure of an in-court identification when they are unsuccessful at getting an out-of-court identification under the more non-suggestive procedure. And I would say that Section 16.1.109, the purpose behind that suggests that we should not allow that distinction at all here, because it would make little sense, and it certainly would not further the purpose that the legislature had in enacting that statute, to require all out-of-court identification procedures to comply with peer-reviewed research protocols, and then allow in first-time in-court identification procedures, which that same research tells us is inherently more suggestive and typically inherently less reliable. And that doesn't make sense for us as a policy for Colorado.
Well, just to follow up, and I know you want to save some time for rebuttal, but Justice Ginsburg's rationale for the majority in Perry, draws in part, I'm losing my thought, I'm sorry. Maybe you should just save. I'll remember it in a second.
Oh, but
I'll
I'm going to
ju- oh,
thwart
sorry.
you.
Go ahead.
What rule are you asking us to create here?
Sure. What I am asking is that a first-time in-court identification should trigger the application of the two-part totality of the circumstances test. And that this court should also tweak that test a little bit for Colorado to include additional factors that reflect what we know about memory and eyewitness identification based off of the research. And those are, the specific list of those are included in the, I can go through them.
One final question. Why, in this case, as an old trial lawyer, I'm looking at it thinking that would be pretty good cross-examination of the witness once they identify. Why isn't that adequate?
Sure, and here there was significant cross-examination of the witness. But in general, the reasons why, for the past 50 years, we have recognized that some eyewitness identifications are inadmissible and are not sufficiently addressed through cross-examination is because juries are not well-suited to assess the reliability and accuracy of these identifications, in large part because this isn't whether or not the witness is credible. It is not whether the jury can look at them and see that they believe what they're saying or that they are telling the truth. Instead, this is about psychological processes that affect your ability to recall information and describe information accurately, sometimes years down the road. And because of that, it is just not well-suited for the jury.
And that was the Perry rationale that I was trying to recall, that she talked about how these things can be just ferreted out through the ordinary process of cross. You can save, go ahead.
Let me
Well,
ask.
I do have one more question relating to
Maybe
the-
not, maybe not.
Relating to the rule, what's the remedy do you want? I mean, do we remand for a hearing if you win, or what's the remedy?
I think here there's plenty of evidence on the record regarding these identifications and the basis for those, or frankly, the lack thereof. So I think this court has plenty of evidence on the record to apply the test yourselves and to reverse Mr. Garner's convictions.
One last quick question before you run away. Is your proposed rule, would that govern in every single case or only where identity is actually contested?
I mean, I think that would be up to this court. There are, of course, many first-time in-court identifications where identity is not contested. And so a number of courts have used that as one of the triggering factors. If identity is contested, then the test should be triggered.
Thank you.
And is it, I'm sorry that we're not letting you go. Would this, my recollection, and correct me if I'm wrong, is that one of the witnesses in this case spontaneously identified your client. What do we do with that? Is it only if the prosecutor solicits the in-court identification?
Here, we made an objection once and that is the third in the line of the three brothers' identifications. And we did object at that point I think because, as Wade said, there's this confrontation that is a state-arranged confrontation, putting the witness against the suspect, that just the mere fact of being called in court to testify regarding those matters is sufficient to trigger that if there's going to be a first-time in-court identification. But at a minimum, if the prosecution elicits the identification, that should be triggered. I would
Okay, you
like to
better
reserve
hold
the
that
last
minute.
minute. Thank you.
May it please the court, my name is Jillian Price, registration number 40815, and I represent the people. Due process does not, in the absence of state misconduct, require a judicial pre-screening rule for first-time in-court identifications. Indeed, the Constitution protects defendants from convictions based on unreliable evidence, not by precluding that evidence, but by affording defendants the opportunity to persuade the jury at trial that that evidence is unreliable and not worthy of being credited.
What do you do with all the social science that says when one of the witnesses did, as the brothers did here, that's him, right there at the defense table, I'll never forget that face in my life. And all the social science says when someone is that confident, jurors tend to believe that. And no cross is going to shake that. What do you do with that?
Well, number one, respectfully, not all the social science says that. The studies by Dr. Mix, as well as Carson and Brewer, Brewer and Weber, and Carlson and Carlson, all raise a few different perspectives within the body of social
They
science.
said confidence is reliable in a laboratory setting.
I'm sorry.
Those studies, if I recall, the ones you're talking about, said confidence is accurate or can lead us to accuracy in sort of a lab kind of based setting.
Well, the Carlson and Carlson study notes that there is the weapon focus effect is not applicable outside the laboratory setting. Dr. Mix and Brewer and Weber note that confidence is, in fact, more highly correlated to accuracy than was previously thought.
So let me take you out of the social science. Do you agree that an in-court setting, a first-time ID in in-court setting is suggestive?
There is, as Justice Ginsburg noted in Perry, there's always some suggestibility in the trial setting. That is not something that can be avoided. However, and speaking more to Perry, what we're looking at is misconduct by state actors, either police manipulating a photo array or a live lineup, or as was the case in Colorado's case in People v. Walker, a prosecutor saying, hey, that's the gun-wielding shooter. That's the guy you should be identifying. When there is misconduct in that sense, then sure, those sorts of identifications should be pre-screened.
Well, may I just tag? Yeah, why isn't this essentially the same thing, right? If you have somebody who's sitting at defense counsel's table, you're sitting behind a thing that says defendant, why isn't that pretty close to saying this is the guy you're looking for?
Well, that is, again, that's the inherent suggestibility in the trial setting. But, and let me flesh Walker out a little bit more. The prosecutor in that case told the witness, the guy that's sitting at the table is the gun-wielding shooter, okay? That is suggestive, that is impermissible, that is the evil that Biggers, Brathwaite, Stovall, Wade, all those cases seek to prevent. Now, a defendant is also, in the United States of America, charged in open court, public trial, but with the presumption of innocence. So even in that inherently suggestive setting, that does not constitute state misconduct by either police or other law enforcement officers, of which prosecutors certainly are one.
Well, let me ask you then, is it misconduct if the prosecutor prepared the witnesses for trial, as trial lawyers do, and in the course of that said, are you sure? It would really help if you would be really sure. Tell us you're confident. In that kind of preparation, is that misconduct?
I don't think that that would be misconduct. All lawyers prepare their witnesses in one way or another, even if only to say or to remind them that they are under obligation and under oath to testify truthfully. Asking a witness whether or not they are confident does not indicate this is the person, this is the guy, this is the one that is guilty, this is the one that you should finger.
Well,
That's,
what about if, my concern, and I suppose what I'm driving at is the concern about phrasing it as misconduct as opposed to just state action, which is due process talks about state action, not necessarily misconduct. I fear getting in a position where we're going to start taking depositions of the prosecutors and ask them what they said to the witness. I mean, that would cause me grave concern, as I would think it would cause you grave concern.
certainly.
So why does it have to be misconduct as opposed to the state action of the prosecutor asking a witness to identify the person sitting behind the sign that says defendant, as Justice Hood said?
Well, the reason I use the word misconduct is because the vast body of case law in these situations talk about impermissible suggestivity and unnecessary suggestiveness. Impermissible and unnecessary, in my mind, and perhaps this is merely a semantic distinction, indicate to me misconduct. The state action of bringing an accused person to trial with the protections inherent in a trial, I don't think could be considered misconduct or unnecessary or impermissible.
But
That's what
isn't a one-on-one show-up effectively impermissible? I mean, and I guess I don't understand how a one-on-one show-up by a police is any different than having the lone defendant sitting at the defense counsel table.
There are some cases in which one-on-one show-ups, so we're looking at impermissibility and also whether it's unnecessary. And if you have an immediate flight situation from, let's say that there is a murder. Let's say that the suspect has immediately fled and is soon after caught. If the victim is there and the defendant is there in order to protect the public and make sure that we either have or do not have a person who could indeed be a risk to the rest of the public, having that one-on-one show up, even if it could be suggestive, could also be necessary. Having a witness identify a defendant in open court under the watchful eye of a judge who is an impartial arbiter and in front of a jury of 12 who can assess the totality of the circumstances would not be impermissible or unnecessary.
Why is it necessary? Why not just have a Biggers hearing, even if you have to do it during the course of the trial?
Well, identity is something that the prosecution always needs to prove. So in that sense, an identification is indeed necessary. Having a Biggers hearing, though, is reserved for specific circumstances where there is state action, and I'll prevent myself from using the word misconduct, but where there is impermissibly or unnecessarily suggestive state action. But Biggers and indeed all of the cases in the Stovall line apply to that sort of state action that happens outside the courtroom, outside the gaze of the judge, outside the gaze of a jury of 12, where there is no judicial oversight and no opportunity for the cross-examination and the other protections of trial that guarantee the fairness, as was the case here.
But what's the harm? The facts here are concerning. I think anyone would admit that. The brothers have widely divergent identifications. None of them picked the defendant out of a lineup. And then 3 years later, they're all absolutely 100% sure this is the guy. I mean, as Justice Marcus said, it certainly seems analogous to a one-on-one show-up in that context. What's the harm by going through this two-step process to be sure? As you know, other states have jury instructions on identification. We don't. What would be the harm? I guess my question, why are you fighting this so hard? It would ensure that we have protection here and we wouldn't be here.
Well, I'm fighting this because I think under Perry and again the other U.S. Supreme Court cases, those have determined that due process simply isn't implicated in this particular circumstance. And speaking to the concerning nature of this case, I would remind the court that the initial descriptions that the brothers gave to police much closer in time to the shooting, they're corroborated by other evidence in the trial and match Garner. For example, Defense Exhibits C and D show that he's wearing an NFL jersey. CD, one of the brothers, said that the shooter was wearing a dark-colored shirt with a number on it. NFL jerseys have numbers on them. We have testimony that Garner wears prescription glasses, and RD initially told police, even though he didn't see who had shot his brother, he knew that that man, or one of the men in the shooter's group, was wearing prescription glasses. So there
Well,
is...
one brother said the shooter is Hispanic and 5'2". He's white and 5'8". Another brother, I think, said, if I'm remembering, said he's shorter than I am, but he was taller.
AD said that he was wearing black clothing and was shorter than him, about 5'5". The arrest warrant specified that Mr. Garner was 5'8", and looking at the Department of Corrections page, of which I've asked this court to take judicial notice, and they have custody of Mr. Garner, report that he is 5'6". They also report that his ethnicity is Hispanic, and Mr. Reyes, I believe, testified that Mr. Garner was... I didn't pull this quote, so I might be paraphrasing, but I believe he said half Chicano, half white, and that was the description at trial. So yes, discrepancies between 5'5" and 5'8", 3 inches, okay. But at the same time, it's the warrant that specifies that Mr. Garner was 5'8", but the one brother's testimony about being 5'5" and the Department of Corrections reporting him as 5'6", I don't feel that that is a very significant difference at all.
Your point ultimately is that, sure, there are discrepancies, but let counsel fight this out and let the jury resolve it after they've heard from both sides. And that's what makes this different. At trial, you have counsel who can do that for the fact finder. When we're talking about an out-of-court identification, typically there's not counsel there to explore those nuances. So that's ultimately your argument, right?
Certainly, yes. And counsel, defense counsel, sitting at trial, hearing everything that's happening in the trial process is in no way, shape, or form hindered from, as you said, ferreting out those discrepancies and establishing and persuading the jury that this testimony should not be credited. And that idea is echoed throughout Perry. Whereas in a photo array, defense counsel typically is not present. And in those circumstances, though they certainly should not, police do have the ability to manipulate photographs. Now, that's not a good practice. They should not do that, but there is less protection and less oversight in those out-of-court pretrial identifications. And that is why the Biggers rule applies to pre-screen those sorts of identifications as compared to ones that are done in open courtroom with oversight and with a judge who can, if an unfair situation arises, take steps to correct that.
Your opposing counsel said that, talked about deterrence. What is it that the Supreme Court said in Perry its decisions in this area have aimed to deter?
Police misconduct, and I have Perry here. So they're trying to just deter the admission of evidence that is so extremely unfair that its admission violates fundamental conceptions of justice. Now, it would violate a fundamental conception of justice for a police officer or indeed even a prosecutor to say, that guy is guilty and that's the one you should identify. That would be impermissible. That would violate fundamental concepts of justice. But that's not what happened here. So the deterrence aspect articulated in Perry, Biggers, Brathwaite, Stovall, Wade, et cetera, is to deter that kind of state action that is impermissible and unnecessary, and to encourage a fair identification circumstance. And in a trial courtroom where there has been no taint by state action previously, where there is a judge to ensure those that a fair procedure is had, there is no need for an additional pre-screening rule.
Should the court, and should we ultimately, if the issue is presented, adopt a rule that say courts need to give an identification instruction? Or do you think Colorado should adopt such an instruction to allow jurors to make the assessment.
Well, this court in Campbell rejected the necessity of a I'm assuming the court is referring to a Telfair instruction, which emphasizes eyewitness identification.
Sure, here's the
testimony,
kind of
et cetera.
facts that you should look at in
Sure.
deciding whether the identification is rational or reasonable.
Well, in Campbell, I believe this court rejected the necessity of a Telfair instruction because juries are given the standard pattern credibility instruction, and there is a danger in giving a Telfair instruction, or indeed any sort of instruction that emphasizes one particular aspect of trial. And it's been a moment since I have read Campbell, but that was definitely a concern. Is it better to give that instruction in light of the fact that now the jury is or has been given that instruction that does emphasize that one aspect of the trial, or is it better to instruct the jury that credibility is a determination for it to make, applicable evenly across the board to all the evidence?
Thank you.
So, Ms. Price, would you agree that courts retain the ability, say under Rule 403, to exclude this kind of evidence?
If it can be established that that it is unduly prejudicial, sure. But as this court knows, all relevant evidence is prejudicial in one way or another.
Unless it's substantially outweighed by the danger of unfair prejudice under 403. And so I know in Perry, in part, Justice Ginsburg talks about how that's one of the things that could be invoked, I suppose. So on these facts, do you think it would have constituted an abuse of discretion for the trial court to have said it's out under 403, absent a Biggers hearing?
Well, I'll answer this question in two ways. First, I will note that the evidentiary issues in this case were not preserved, number one. Number two.
Oh, it's just hypothetical.
Oh, certainly. I just, it's my job to advocate.
No, I appreciate it.
In any event, I think it would have been, I do not think that these identifications were unduly prejudicial, and I don't think that there was any undue prejudice that outweighed the probative value of these identifications. This is more a matter of weight than admissibility. Again, that is to be ferreted out through cross-examination and argument, which defense counsel did quite vigorously in this case.
All right, thank you.
Thank you. Unless this court has any further questions on any aspect of this case?
I guess excuse me, I'd be interested in knowing whether you think the fact that all three of the brothers had failed to pick Mr. Garner out of a photo array is of any significance, that the only other time they had been asked to identify him, they were not able to.
Well, there's a difference in seeing a flat two-dimensional picture of someone versus seeing them live and in person. So I don't think, I mean, while their inability to identify Mr. Garner from a photo is certainly relevant and certainly, again, grist for cross-examination, that is not fatal to the identification made here. There are differences in body language, tilt of the head, expression of the face that simply do not always come through in a two-dimensional photograph. So in that sense, given that this was the first time since the shooting that the brothers had seen Mr. Garner in person, that does not diminish the reliability of the inability to pick out the photographs does not diminish the reliability of their identifications here.
So if, hypothetically, instead it had been a live lineup and they had failed to pick them out of a live lineup and then identified them in court, would that make a difference?
That might be more problematic, but I still don't think that would be fatal to the admissibility of the identifications, and that would still be a matter for cross-examination and testing of the reliability under the protections of the trial system.
So in your view, a first-time in-court identification never triggers a Biggers analysis?
Provided that there is no impermissible or unnecessary state action, that is correct.
Isn't a big part of the problem here is that they're seeing him for the second time, right? Because, you know, even if they weren't able to pick him before, they saw him as one of six, I think it was, right?
In the photo array? Correct.
Yeah. So they're seeing him for a second time. At some level, the image of him is already in their brains. Is that I think that's a big part of the concern. Wouldn't you concede that?
Well, perhaps, but as the transcripts and as the record shows, and as Justice Gabriel touched upon earlier, the pictures in the photo array, two of them had facial hair, none of them had hair on their head, and none of them were wearing glasses. So the photos, so yes, Mr. Garner was in the photo array and they did see him there, but he did not appear in the photo array as he did on the night of the shooting, again, wearing glasses, et cetera. So that is a concern to take into account as well.
Does it just come down to whether we're going to have the jury or the judge make the reliability determination when it comes to in-court identifications?
Well, and that is precisely what the jury is to do. Juries weigh the facts and make those credibility determinations. And frankly, having 12 sets of eyes and 12 voices in that deliberation room inures more to the defendant's benefit than having, one single determination of those kinds of things. Unless this court has any further questions, and with my remaining 10 seconds, I will respectfully request that this court affirm. Thank you.
You.
Here, the question is simply whether or not an analysis is triggered under these circumstances. And it is not a question of per se admissibility. And what we are asking for is for this court to tell trial courts that they need to assess the evidence when there's a first-time in-court identification for reliability, because we know that there is a heightened danger of irreparable misidentifications.
But isn't that what Perry said it was not going to require? Trial courts to conduct a pre-screening hearing every time there was going to be an in-court identification?
Perry did not specifically say that, I don't think, no. But Perry did say that in every single case where there's eyewitness identification, they were not going to require that. This because of the first-time in-court identification and the follow-up of the previous out-of-court identification in which the brothers were exposed to the photo and then failed to identify the defendant. That increases the suggestiveness of this in a way that does trigger the test. And if this court does not, I'm sorry, I see I'm out of time. I would ask that this court reverse convictions. Thank you.
Thank you. Appreciate the argument of both counsel. The case will stand submitted, and the court will be in recess until 9 o'clock tomorrow morning.